Can Wendi Adelson be impeached by statements that she made written into a work of fiction and published prior to the murder of her husband? My answer is no, but we'll have to wait for the court's answer. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. So let me start by saying that if you're planning a crime, like, oh, I don't know, say murder, don't lay out your thoughts in a book either before the crime, Adelson, or after the crime, Corey Richins. It's just not a good look, even if it is completely and totally coincidental. It's just not a good look. I want to point out a couple of things first, though. A few years ago, I wrote a book about a bad girl from a tough home life who, along with a new boyfriend, started robbing banks for fun and profit. Let's be honest, it was a terrible book. The sequel was even worse. You'd think I would have learned my lesson the first time, but it was bad because I had to address all the flaws from the first book. And the final book in the trilogy was probably the worst of the worst because it wrapped up in what I've been told is the most ridiculous way possible. But the book had lots of information in it about banks, bank robberies, firearms, bad guys, bad people, actual criminals, and many of the people in the book were based on people that I had run into during my time as a trial lawyer. I drew from some of my personal experiences to write those characters, but those characters had different names and they were all sort of a collage of these different people. And in addition to all of that, it had a thoroughly unbelievable protagonist who was a respiratory therapist. What can I say? It's how I came up. And an obstacle character who was a female FBI agent who only had eyes for women. My point is that I'm not plugging these books. Please do not go out on Amazon and find them and read them because you'll lose all respect you have for me. My point is that although I did a lot of research on bank robberies and watched the movie Heat, I've never actually robbed a bank. So if someone believed that I had robbed a bank and I was on trial for it, it might actually be relevant if there was something in there that related directly to that bank robbery. And if I took the stand in my own defense, I could be impeached with it because it would be directly relevant. But I don't intend to ever rob a bank, and I don't even intend to be in the same zip code when one is robbed if I can at all avoid it. I lay this out because I think there are a lot of things that people don't understand about the process of impeachment, which we're going to talk about today. So, Wendi Adelson wrote a book about a character named Lily, an immigration attorney, and it got 3.5 stars on Amazon. Lily was in a small town because of her thoughtless husband, and she was pretty browned off about it. I don't consider Tallahassee to be a small town, and that's where she was living, not some podunk place out in the marshes of Florida. But because the Lily character is an attorney and there are statements about her being unhappy, the state would like to impeach Wendi Adelson when she testifies with her prior writings. And Donna Adelson's lawyers would like to keep the book out. Let's watch a little.
Uh, with that, Your Honor, the significance of that date is obviously it was prior to when Miss Adelson filed for divorce in 2012, certainly about 2 years prior to the hearing where her petition for relocation was denied. The reason why those dates are significant in Charles Adelson's trial, Your Honor, the state's position was that the storyline of Miss Adelson's book was relevant for impeachment purposes because the defense's cross-examination opened the door. And I quoted the argument that was made on August 30th of 2024 by Ms. Kappelman concerning why she believed the door was open. Well, I first want to submit, Your Honor, the concept of opening the door is triggered when one party's evidence presents an incomplete picture, and fairness demands the opposing party be allowed to follow up to clarify and make it complete. That's from Brunson v. State, 31 Southern 3rd, 926, a Florida, first DCA case from 2010. Now, the underlying.
Before you go on with that, and that case does bring up a good concept, but isn't this largely dependent on what Miss Adelson is going to testify to on the stand?
Yes, but in order for it to be proper impeachment, the underlying requirement, I think that's inherent in the rules of evidence, is that the fact that the opposing party wants to clear up is actually true. And so the state has to take the position that this is our story, written by Miss Adelson, is autobiographical. And because it's autobiographical, how the main character feels about the city in which she lives with her husband, who's a professor, is relevant almost 2 years after the fact to how Miss Adelson felt about having to remain in Tallahassee after the petition for relocation was denied. Now, the main fallacy of the argument, however, is that first and foremost, the book is not autobiographical. And I've read the book. I have the manuscript that was originally submitted to the publisher. The main character had a miscarriage, leaving her unable to have children, and she ultimately adopted a former client's abandoned child. There's no evidence that Wendi Adelson did those things. And that's just one glaring example of how the book is not autobiographical. The state's position is factually inaccurate. The state's position, both in the hearing and prior trial, was that the main character of this book, Lily Walker Stone, was utterly miserable and stuck in the place she was living. Now, that position would have been accurate if you stopped reading halfway through the book. On page 233 of the book, there's a passage I'd like to read for the court that highlights the fallacy of the state's position.
Go ahead.
I'm so sorry, Josh, for everything, and I'm grateful to you, for bringing me to this place, for giving me wings to try something new, and for all the unpredictable experiences that have followed. She's thanking her husband for bringing her to the fictional city in which they live, the fictional city in which he teaches, the fictional city in which she practices law.
Those are pretty good arguments, and we'll see why in just a second. According to the Squib on Amazon, the book is about the lives of Rosa and Mila, two young women from different countries who become victims of human trafficking when duped into domestic servitude and other things in the Southeast. The experiences with the underbelly of globalization in the U.S., it's sort of in our own backyard, and the legal battles they wage against their traffickers with their immigration attorney, Lily, are told in their own voices and hers in vivid and compelling detail. You can tell that was written by the author and not by someone who read the book. Anyway, I'm having a lot of trouble seeing how a work of fiction can ever be used as impeachment material. First of all, there's no allegation in the Donna Adelson case that Wendi had any part in taking Dan Markel's life. And that's because they are trying Donna, they are not trying Wendi. So the only purpose to bring this in would be to impeach Wendi, because it's not substantive evidence against Donna Adelson. It doesn't mention Donna. It doesn't talk about mother-in-law. It doesn't talk about the lawyer's mother in any cognizable way that would make it valid as something that could be admitted as evidence in that case. But before we get there, we need to talk about impeachment as well as how it's done and what are its limitations. Impeaching a witness with a prior written statement during trial challenges the witness's credibility by demonstrating inconsistencies between their current position and their previous position. Here is sort of a step by step on how that process works. First, the witness says something that is inconsistent with the impeachment material. So Wendi would have to say something that is inconsistent with the book. And the attorney must first establish that there's this discrepancy before they can move on to impeachment. In order to do that, the attorney must lay a proper foundation, and that involves asking the witness about this, the context in which the prior statement was made. Didn't you write a book about human trafficking? And then you establish the witness recalls making the statement, yes, I wrote a work of fiction about human trafficking. Establish the reliability of the statement. You were writing about your own experience, weren't you? And of course, here it doesn't matter whether she says yes or no, because it's the question, again, that makes the point, not the answer. Then you confront the witness and ask about the specific part of their testimony that's inconsistent with the prior statement. This usually involves the question to confirm the current testimony. You just said, Miss Adelson, that you were not angry at your husband. Yeah, that's what I said. So you introduce the prior statement. Once the inconsistency is established, the attorney can introduce the specific portion of the prior statement that contradicts the witness's current testimony. Isn't it true that your character in your book says that her husband was a maggot eating, cesspool sucking, two-time, knobby kneed creep with excessive body hair who dressed funny and smelled bad? Full disclosure, I made that part up. That's not in the book, I'm sure, but it would be cool if it was in a book. Just have to say. If they ask the question the right way, they can get it in. The attorney then asks if they recall making that statement. And after confronting the witness with the inconsistency, the attorney can ask her to explain the discrepancy. And of course, my guess is that Wendi Adelson would say, Mr. Prosecutor, are you familiar with the whole concept of fiction? Just asking. Anyway, there are other requirements. The attorney has to authenticate the prior written statement to ensure that it's admissible. In other words, he's got to bring the book into trial. That means demonstrating that the statement was genuine, made by the witness, and depending on the rules of evidence, the document itself may be admitted into evidence, particularly if the inconsistency is significant and it's material and it's relevant. But those are big hurdles in this case. And that's because impeachment is limited by the rules of evidence, particularly relevance and materiality. The prior statement must be relevant to an important aspect of the case and material to the witness's credibility. Whether Wendi was angry at her husband at some point is not relevant where Donna is on trial, because there's no claim in Donna Adelson's trial that she set this up for Wendi. So, again, it's impeachment on a collateral matter. So let's talk a little bit about the collateral matter rule. Impeaching a witness over a collateral matter is generally not allowed at trial. A collateral matter is an issue that is not directly related to the substance of the case, but might relate to the witness's credibility or reliability. The rules governing whether a witness can be impeached on such matters aim to maintain the focus on relevant and material issues and avoid this unnecessary distraction or confusion during trial. A collateral matter is something that does not directly pertain to a fact at issue in the case. And as I said, her being angry at her husband doesn't pertain to an actual matter in the case. It might involve background information or peripheral details that do not affect the main question the trial seeks to resolve. In this case, the main question the trial seeks to resolve is whether or not Donna Adelson paid her son to go get Dan Markell eliminated. So whether Wendi was mad at her husband at some point, or whether they were disagreeing, whether they were, whether they hated one another, any of that is really collateral to the issue because Donna Adelson is on trial, not Wendi Adelson. And like I said, there's no allegation that she did this on Wendi's behalf, although apparently no one in Tallahassee actually believes that. I get lots of comments whenever I make a video about Wendi Adelson because people really do believe that she's guilty. And of course, if I were one of these lawyers in that particular venue, I would take all of those YouTube comments and I would truck them into the courthouse and lay them in front of the judge and say, we need to change the venue because my client cannot possibly get a fair trial here. But that's another issue and another situation. So again, I'm not advising anybody. I just think sometimes lawyers miss a lot of really useful material that they could use if they tried to use it. So If the collateral matter significantly affects the overall credibility of the witness, it might be permitted, particularly if it reveals bias, motive, or a pattern of dishonesty. But remember, judges have the discretion to determine whether the probative value of impeaching on a collateral matter outweighs the potential for confusion or prejudice. They may allow it if it provides important context or insight into the witness's truthfulness. But again, impeachment is about truthfulness, not about whether somebody was, you know, somebody might have an ulterior motive to do whatever it is they did. Under Florida law, the right to impeachment is limited as to collateral matters. Generally, it's not permitted. In New England Oyster House of North Miami versus UHAS, in New England Oyster House of North Miami versus UHAS, a personal injury action for damages sustained when a plaintiff fell on a concrete curb and sustained injuries when she tripped and fell, the trial court properly refused to permit defendants to impeach plaintiff's credibility with her statement in her deposition that she lied on her income tax returns. That was because she gave up her lost wages claim, which was the only thing that made those tax returns relevant in the litigation. And absent the tax returns being admissible, it was a collateral matter. You can see some overlap there with this Wendi situation. In Foster versus State, Florida courts said the test for determining whether a matter is collateral or irrelevant is whether the proposed testimony can be admitted for any purpose independent of the contradictions. Could this book be admitted for any purpose absent the contradictions? No, because it's Wendy's work, it's not Donna's work. Applying these rules to this precedent, it seems fairly clear to me that whatever value it might have to show that a work of fiction contains some dissatisfaction between husband and wife, and the witness's husband being murdered by thugs 2 years later, that's tenuous at best. Wendi has never been charged or linked to the killing in a substantive way, or shown to be directly involved. There are some circumstances which certainly point to a reasonable inference that she is, but again, that's only an inference. And a jury would have to make that inference in an action against Wendi. Over on Court TV, they believe the judge is going to allow this to come in. I'm not so sure. But if he does, it provides an appellate issue for Donna because it's clearly a collateral matter. It's an issue on appeal, but it probably won't be a winning issue because it's an evidentiary issue. And pretty much only when an evidentiary issue is so significant that it slants the trial in favor of the state is the issue going to result in reversal. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.